Good morning, good afternoon, and good evening, ladies and gentlemen. My name is Elijah Dominguez. I'm making this video today in regards to the Contra Costa County Sheriffs. I'm making it today this video today to show individuals that the Contra Costa County Sheriffs are corrupt, that the Contra Costa County Sheriffs have been involved in withholding public information from the general public and trying to claim that there was investigative privilege to conceal the records of misconduct by public employees. As you can see here, this is Government Code 6250. This is the Public Information Request Act. This is where you get all your state and local information. Now, the reason why I think this is incorrect is because I just spoke with dispatch, and dispatch told me that the cases are not under investigation. Now, there's a case called Gooden versus the City of Glendora, and this case was involving a Public Information Request Act, where they had asserted that there was a investigative privilege, and the case was obviously taken to trial, and the case was later overturned when they said that the police did not have investigative privilege. Now, the reason why I'm saying this is because I filed a public information about 2 days ago, and I had requested public information in regards to 3 officers who had body camera footage in regards to an incident that took place here on May 15th as well as May 13th. These deputies, Chang, Guido, and Venezuela, and had not provided information regarding the body cameras. I received this yesterday, stating on the 27th here at 8:45, stating, "Hello, please find some items you requested in the call log. Please be advised that the call audio is exempt under California records, and we do not release it. As far as worn body cameras and personnel files, you will need to contact our record department if that is something you are able to get." Now, as you can see here, there's a file here. I've already opened it, but this is the actual call log here. And you can see here, this is the call log incident number. These are the 2 of the incident numbers that were filed. And this was from the Contra Costa County Library in Crockett. And this is, as you can see here, it says Certified Original Master. So this is an original file. And as you can see here, there's 2 more incidents in which he had called the library. Now, these are all public information and available and open to the public. So what I did was I filed an appeal under 6258. As you can see here, California Government Code 6258. That's a typo. It's not penal code. It should be government code. As you can see here, I requested information explaining to them that it's a government agency and that they had to release public records. I quoted the State Assembly Bill, SB 1421 and 748, telling them that the records are not exempt. Under that case versus Gooding versus the City of Glendora, that case shows that there was not that case, even if I took it to court, that it would just be overturned because there was obviously no investigative privilege. I'm going to actually, after this, show you the video. As you can see here, it says, "Dear Mr. Dominguez, here's another response at 5:10 a.m. today." Today is May 28th. And they said, "We provided you an email in regards to requesting audio, and it's declined to provide such records. The request of the complaint or investigation conducted by law enforcement are exempt." But we're going to show you the audio here now and why they are not exempt and why Glendora versus the city of Gooding versus the city of Glendora. That is city versus Gooding versus the city of Glendora. And you can see it's this case right here. Gooding versus the city of Glendora should overturn this case. And so we're going to go ahead and start the video up for that. But I want people to go ahead and read this record here. You can go ahead and slowly read it. You can even look it up yourself. But this shows that there was no investigative privilege. So let's get that video started here. Okay, let's get it started.
Press 1. For Spanish, press 2. Nothing has been selected. Please hold while I transfer your call.
Yes, hello. I just called. I don't know if I spoke to you or another.
Regarding what?
In regards to case, several cases, 3 incident.
And how may I help you right now, Elijah?
Um,
What do you need right now?
I was just trying to. I had a little confusion with the report. So I was. We spoke before, correct?
We did. So tell me what part you're confused about.
Could you explain it just one more time? I just so.
Okay, so in conclusion, Elijah, the police sergeant told you that per the library you were suspended for 1 year.
1 year.
What part is not clear for you?
The
you need me to have the sergeant call you again?
No. I was just trying. I'm just. So none of these cases are under investigation. These are just incidences that occurred. Is that correct?
That is correct.
Okay. And I was just wondering why the officers enforced a First Amendment freedom of speech.
So Elijah, it's for some reason the library wanted you suspended from the library for whatever you were doing in the library that
Cursing.
They were not.
I was using
that they were not satisfied with. So whatever you were doing in the library that made the library decide to want to suspend you for 1 year, we have no control over that. We're not the ones that made that decision. The library did.
Understood.
So I can't continue to go over with you over and over again about it.
No, I'm just. I was just wondering because. I was just wondering because I filed a public information request and I was told that these were under investigation. That's why I'm asking.
Public information request comes from the records department. That's
no,
still not a case.
I did. I know that. I understand that. I'm explaining to you that I filed a public information request. And when
so you're telling me that for what?
The reason why I'm telling you this is because you're telling me that it wasn't under investigation, that there's no investigation, and the person that did the public.
I can't go with you back and forth about this, so I can have someone call you back.
No, it's okay. It's okay.
We're either done, or I can have someone call you back. Which one do you prefer?
No, I was just having.
You want for the deputy to have them to tell you again that you're suspended for a year?
No, it's not. It's not that at all. It's the fact that I'm being told that the file's being under investigation and that it's subjected to.
There is no investigation. It is not. There's no case number that was requested.
No. Can I finish, please?
You have to listen for a moment. You keep saying no, but you're not listening to what I'm saying.
You're not letting me finish my sentence, though. I filed, so
But I did many times. You're only saying the same thing over and over again. I've offered you to have an officer to call you back, but I'm not going to listen to you say the same thing over and over again. No,
it's just the fact that it's interesting that I filed because I used a dispatch email, because I was asking for audio for the non-emergency call for these incidents.
So if you want audio from the officer's body cam, that's what you're saying? You want their audio from their body camera footage? That's what you're saying now?
Well, I did a public information request, is what I was saying, is when I asked, that's what I was trying to explain to you, is when I did the public information request for these incident numbers that you gave me, the incident numbers that I just gave to you, they actually stated that the information was under investigative privilege, under 62, 55, and 54. So I was just confused about that because you're telling me it's not under investigation and they're telling me the opposite. So I was just
telling you that.
It was through an email, through public information email.
Right, so why don't you email that person back, whoever sent you an email, and email them back and ask them for those case numbers if they're saying there's a case number. Why don't you email them back?
Okay.
They emailed you that.
Okay, thank you
Why
so.
don't you do that?
Okay, thank you so much. I was just trying to figure out if you could clarify for me.
You don't have to repeat everything all over again. We've already did that. Is there anything different you want to say right now, or no?
No, I just wanted to say thank you, and you have a nice day,
go ahead and go then.
and take care. Thank you.
Okay. Alrighty. Goodbye.
Thank you. Have a great day. Take care now. Thank you for keeping our neighborhood safe. I really appreciate it. So as you heard there's no investigative privilege, and the DJ just stated that they had investigative privilege, but you could hear there that the case is not being investigated. These cases that are being looked at, that are being requested, are not being investigated. They just don't want to give the documents.
A phone call from us?
Yes, about the incident that occurred.
What's going on?
So I'd like to press charges for a hate crime against the individual Mark Batchefer.
Against who?
Mark Batchefer.
Who is that?
That's the librarian you talked to?
Okay, what's the hate crime?
The hate crime is discrimination against the disabled for uses of a public facility.
That's not discrimination. If there's issues with policies, he's not discriminating against you for the policy violation.
So there was a case before this court, and before the Contra Costa County Court, and this case was regarding this same exact thing that they called you for on April 30th, before Anna Young, and the judge ruled in my favor in Department 50. And said that the case was dismissed because it lacked merit for First Amendment protected activities where I grieved against them for being disabled and not being able to easily access the door. The individual lost that suit on April 30th. The case was dismissed, and he even told you that case was dismissed. And then you proceeded as an officer to enforce a policy that was unconstitutional, that the courts already ruled on unconstitutional. And like I said, I want to press hate crimes because the courts already ruled in my favor about this disability already, and now you're telling me that you're not going to enforce the person discriminating against me, who has clearly discriminated against me, where there's court cases.
That case was dismissed. It wasn't ruled in your favor. It was dismissed for lack of evidence.
Which is basically equivalent enough to say that.
That's not the same.
So
that's not a ruling in your favor. That's the case dismissal.
So a case dismissal.
Winner or loser.
So a dismissal is not a ruling in my favor?
Correct. A dismissal is based on not enough evidence. If there wasn't enough evidence to proceed with the case, then the case will not go forward in the system. So it's basically dropped. That's not a ruling. That's a dismissal.
Yes, and the ruling was to dismiss the case, correct?
No, the ruling is either guilty or not guilty. If a case is dismissed based on lack of evidence, you can't even go forward to the part of guilty or not guilty.
So there was lack of evidence for my cursing in the library, for the behavior that they said before, and they're doing it again. And you're telling me that this isn't harassment when the case was dismissed already for the same things they just called about?
No, it's based on everyone being accountable for the same actions. It's not harassment. If they were singling you out for such an incident, then yeah, it would be harassment. That's not harassment. If they hold everyone to the same standard, that's not harassment.
Did you?
They didn't trespass you from the property. They're allowing you to continue to come onto the property.
Yes, but you did give him. Sorry to cut you off, but you did give him the decision whether or not to make me leave based on the language that I was using, correct?
Basically, I gave them an option to let you leave on your own free will versus trespassing, so you were able to come back to the property.
And I just had a question. What was the name of that form again for trespassing?
It's called a 602 form. It's a trespass form.
Oh, okay.
That means you can't ever go back to the property ever again.
Okay, and that wasn't given to me.
Correct.
Okay.
Which means you're allowed to go back to the property.
Okay. Okay, thank you so much.
You're welcome.
Have a nice day.
You too.
Goodbye. If you have watched the video up this far, I'm going to show you now why the library is full of shit. First off, the library cannot enforce a policy that goes against the First Amendment. That includes prohibiting free speech. The only free speech that can be prohibited is fighting words, in which using foul language to express oneself because the power went out and there was a deadline that I had in a civil case that I could not meet, and I was upset, and I used foul language in order to express myself. The library then told me not to. I told them I can curse if I want to. I am expressing myself. As you can see here, it says using harassing language or insulting language, including profanity, is prohibited. Well, under the Constitution, Article 1, the very first one in the book says that we have the right to freely express ourselves, including profanity. And Cohen versus California, New Hampshire versus Chaplinsky, they cannot force an individual in a public facility, in a public place, to control their language because they are offended by me expressing myself because of the computers going out, because of a power outage, because PG&E cut the power. Now, another issue that I had was that the library was enforcing pervasive odors that could cause a nuisance, including pervasive fragrances caused by perfume. Well, that's a Fourth Amendment violation. You cannot control a person putting fragrances or perfumes on and tell them you can't come into the library if you use a perfume or fragrance because it's an offensive smell or odor. And they cannot prevent scented products. They cannot prevent me from entering into a library and control the way that I smell or the way that I speak. This is a clear violation of the Fourth and First Amendment. And the sheriffs, as you heard in their conversation, stated there was no retaliation and that this wasn't retaliation, which is full of crap. As you can see here, there was a suspension on 3/13, right there. And who was it issued by? Gia Paolini. And she was the person issuing it. And I was suspended for 1 month. Now, the reason why was because I filed a complaint to the Civil Rights Division. And I had filed a complaint against the agency for denying me public access to the library and was denied the rights to participate in their public program because of my smell and the use of freedom of expression. Now, prior to this, I filed a complaint, as you can see here, March 13th. I filed a complaint, and I had filed a complaint against them for retaliation of the original complaint, which I'll show you here. But this is the retaliation complaint, which led to the May 15th suspension. As you can see here, this is another complaint that I filed. I think that's just a copy. Here's a copy from May 12th, March 12th. Allison Peterson, as you can see here. And it's a complaint regarding the right to carry. That's Carrie Kipp. And I filed a complaint in regards to freedom of expression and the right to freely express myself. And you can see here, here's the original complaint. This is a follow-up complaint to the complaint that was filed in regards to the decorations of art and pumpkins and where I was denied a public program. I explained to them that I had disability, and they knew I had disability. And they continued to retaliate for these actions. This is why the library is full of shit when it says that they're the victims and they're scared for their safety, and the sheriff saying that there's no misconduct or wrongdoing because the library has the right to tell me I can leave a public facility. And that's not the case, especially not for free speech. As you can see here, January 1st, Susan Scamser and Anton Wilson, these are the risk management people. And I filed a complaint there. And they knew there was a complaint that was filed against them and that I had complained against their office in regards to the obvious discrimination and denial of public access to a public program. On March 12th, again, there's another conversation that took place. They said they took the complaint serious and that they actually went and sent it to their attorney. And the attorney, Tiffany Yachuri, looked at this information and said that it was valid, that the policies were valid. And this was not the case because obviously you can't prohibit free speech, especially cursing or expressing oneself. That is just a copy of the follow-up complaint. But as you can see here, I did file a complaint. Here we go. Here's the original complaint. February 2nd. Good morning. And you can see here I filed an intake review. And I filed a clear picture of the allegations, all the phone number information, and provided all the information to the EEO officer who was investigating it. As a result of that complaint, give me a second here, I was giving another suspension for 1 year by the Contra Costa County Library. This 1 year suspension was because I had filed the EEO complaint in regards to retaliation for the DOJ complaint. And the library enforced these policies. And when I called them on it, they proceeded to have and manipulate the sheriff's department in order to gain, to have me removed, obviously, from the library. This is why they are full of shit. They retaliated, and crimes have been committed. The librarians cannot retaliate on you for filing an American with Disabilities complaint. This is a violation of the standards of law. And the fact is that the Contra Costa County Sheriff, Scanlon, stating that there's no violation of retaliation is absolute bullshit. And it shows that the Contra Costa County Library violates the law, does not care about retaliating against people who are disabled and claiming that they are disabled, and they also knew about my disability. I filed an appeal, and the appeal was actually denied for the 13th. That's when I was handed the suspension for 1 year, because I had the balls to complain and say, hey, they are not complying with the ADA standards of rule, and the police decided to engage in activity that was unlawful as well as the librarians. And it shows that Mark Batchefer, Amy Brunson, and all the people that have been involved, even Allison McGee, who was the one who did the appeal, retaliated against Elijah Dominguez for his DOJ complaint and for his complaints to the city in regards to disability violations and violating his rights under the ADA. And the fact is, the library does not care about the rights or privileges, and will even use individuals who are praising them for their misconduct. This is the type of behavior that the agency does in order to keep itself from wrongdoing. And I wanted to show this behavior of the library so that people could see the Contra Costa County librarians are corrupt and the sheriffs are aiding these corrupt librarians. And that this behavior is not okay, and that the librarians should be fired for their behavior and retaliation. And Contra Costa County will not fire them and allows them to stay. And I just wanted to show this so that people would know what is really going on and not give in to the lies and deceit that Mark and the librarians are trying to give. They are trying to give a slanted version of what really occurred, and trying to gain and curry favor with others, trying to get others to favor them, curry favor. And so they're trying to gain sympathy. But don't buy into their sympathy, because they are dishonest, they are liars, and they will willfully and knowingly violate your rights and privileges, even if you file a legitimate complaint in regards to violating of law. Thank you for watching. Share, like, and subscribe for more content. And until next time, God bless America, and thank you for watching.